Now, in this module, we are going to study essential elements of a valid contract. Now, Section 10 of the Indian Contract Act 1872 mentions some conditions that make a contract valid. Like those conditions are an offer, that an offer has to be made by some party to other party or parties. Then there is acceptance. The other party or parties must accept that offer, and there has to be a free consent of all the parties. Now, possibility of execution. The contract or the agreement that has been made must be executable. There cannot be such a contract that is impossible to execute. Like if you ask someone to bring someone back to life and there is an agreement between two parties, and the other person will never be able to bring back someone to life, as we know that this is a fact. So that is called possibility. That comes under possibility of execution, and in this case, and the example given, that this agreement is not executable, so it can never become a contract because it will not be enforceable by law, because court never issues such decree that can never be executed. So even if court issues an order, it will not be executed by any of the parties because it's impossible. So such sort of agreement can never become a contract. Now, so there has to be a condition that there is possibility of execution of the agreement that you are entering into. Now, apparent form of contract. There has to be an apparent form of contract. That has to be like it is verbal, like it is written, and if there are certain terms and conditions that must be mentioned in some sort of contract, that they have to be there. So apparent form of contract now. So it is verbal or in writing. So this is pertaining to that. So intention to create a legal relationship. So there must be an intention between the people who are entering into a contract or the parties who are entering into the contract, that they intend to create a legal relationship. There cannot be some friendship relationship, okay, that you come to a party at my home and then you do not reach and then you claim that it was a verbal contract. So there must be an intention to create a legal relationship. So friendship is not a legal relationship. You promise something to your son or daughter, it's not a legal relationship. So those are excluded. So now comes lawful object and lawful consideration. The purpose of the contract must be lawful. You should not enter into such agreement that is illegal. And there must be lawful consideration. Consideration is what you give and what you take, or what you do or what you do not do for someone else or for other party. So there has to be lawful consideration, that is legal consideration. That should not be illegal, like if you say that, okay, I'll give you some money and you supply me some arms and weapons, those are forbidden by law. So that is not lawful, that is illegal. So such sort of agreement cannot amount to a contract. And then comes contractual capacity of the parties to contract. So the contractual capacity, that the capacity of the parties, they should have contractual capacity, like minors are not competent to contract, and some illiterate people, like some women who observe whole or partial V's or parda, who observe parda system. So as they are considered as illiterate, so they cannot enter into a contract, or you cannot enter into a contract with them, because it is considered that they do not know what they are entering into. So they are not competent to contract. And but it is also subject to court orders, because court issues orders from time to time. Sometimes they consider that those women may be, in the case of women, but in the case of minor, they are not competent to contract. And then there comes legal formalities, like if you are entering into an agreement with some other party, and regarding such agreement, if some other laws are applicable, because you are entering into a contract or an agreement that is covered under some law, and you must observe those laws, and you need to follow them. And if you are entering into such an agreement that violates those laws, then you cannot enforce that agreement in the court of law. So you must keep in mind other laws, those are applicable. Then consensus ad idem. So there has to be consensus of all the parties in the same sense for the same objective. And so this was about essential elements of a valid contract or an agreement that must amount to a contract. Otherwise, that agreement will not amount to a contract if it does not contain these elements. Now, let us study these elements in detail. Now, the first element was offer. Offer under Indian Contract Act 1872. The word offer and proposal are used synonymously, that is interchangeably for each other. Offer is the first step in the formation of an agreement that will further lead to a contract, because first you create an agreement, and if it is enforceable by law, it becomes a contract. Okay, so according to section II.I of the Indian Contract Act 1872, when a person, let's read it as when one party signifies to another party their willingness to do or to abstain from doing something with a view to obtain the assent of the other party, it is said that the first party or the person who is creating an offer or the party who is creating an offer have made an offer or have made a proposal. Now the person who makes an offer is called an offerer or promiser, and the person to whom the offer has been made or the party to whom the offer has been made is called an offeree or promisee. So here when we say person or party, so party will be most appropriate, because all the times it is not that we enter into an agreement between people, because there are also some other entities, like there may be a trust, there may be a company, there may be a partnership, and two partnerships may enter into an agreement that can amount to a contract. A person may enter into a contract with a company, and that is an artificial legal person. So, and of course there are people who make signatures or who represent their organizations or the entities, like if a company secretary is representing a company, or maybe a CEO is representing a company, and on behalf of the government there may be a secretary level officer who represents the government or its department, like health department. If health secretary marks their signature on some agreement, of course this means that health department has made an agreement, and you can get it enforced in the court of law. So this was about it. So now we should study in detail that what are the essential elements of an offer. In an offer, first there should be multiple people. An offer cannot be with one person or one party only. There must be at least two or more parties. One is the offerer and the other is offeree, or few are offerers or few are offeree, because there can be a contract between multiple parties as well. So then the second one is communication to the offeree, like a person who is creating an offer or making an offer must communicate it to the other parties to whom the offer is being made. They cannot keep it with themselves and they say that they have made an offer, because then an offer must be communicated to the party to whom the offer is being made. An object of making the offer, there has to be an object of making an offer, and of course that object must be legally viable. And then clearly defined terms of the offer. The terms of the offer must be clearly defined, because if you do not define them, you will not be able to claim it in the court of law. And even you will not be able to claim it before the other party, because they were not clearly defined. If there is nothing defined, then what will you claim? There is nothing. So if it is clearly defined, then you can clearly claim it. Even if there is ambiguity, then later on the other party will make counterclaims. So if you want to make an offer valid, so it has to be in clearly defined terms, because even if you present it in the court of law, then the court will get confused and they may dismiss your petition. So, and then it may contain specific terms and conditions. You can lay down specific terms and conditions as well. and there can be an offer that is unconditional or deeming acceptance in case of non-fulfillment of some specified conditions. Like if you do not fulfill some conditions, it will be deemed that you have accepted the offer or the offeree has accepted the offer. If you want to take an example, then I can give you an example like you get an email. If you have registered somewhere, you get an email and they say that if you have not registered, then you click here and we will remove you. And if you abstain from doing that, do not do anything if you have registered yourself. So if you are not doing anything, this means that you have accepted that offer and you have registered with their site or with some online services. So this is an example that you can cite under this unconditional offer. Like you are not going to do something, but you are just going to abstain from doing something, and it will be deemed that you have accepted the offer. Like if you want to take an illustration, that there is an illustration as well. Like there is Miss A who owns several machines. She enters into an agreement with Ms. B to sell one of the machines. That is, she makes an offer to Ms. B to sell one of her machines. She tells Ms. B if she is willing to buy her machine for rupees 10,000, then she will be willing to sell it. This is not a valid offer because Ms. A did not specify which specific machine she is talking about, because she has multiple machines. So here the offer by Ms. A is ambiguous, that it is not clear. So there has to be clarity of offer, otherwise you cannot claim it, and this we study in point number 4. Okay, now acceptance. Now what is acceptance under Indian Law of Contract or Indian Contract Act 1872? When a person to whom the proposal or the offer has been made conveys their assent, it is said that offer has been accepted or that has been an acceptance. And there are some conditions that makes an acceptance valid. The first is that acceptance must be absolute and unconditional. That a person who accepts that offer must accept the offer as it is. If they have to make a counterclaim, they make it beforehand and then accept it, because then it will be deemed that they have accepted the final draft or final version of whatever is being offered. And then it is not that they cannot make any claim or they cannot negotiate on that contract. They can negotiate, except a few exceptions, like when you register online, then they do not provide you any negotiating capacity that you can negotiate with them. But in most of the cases, of course, you can negotiate with other parties, or the offeree can negotiate with the offerer. But after the final version has been created, after the final draft has been created, they have to accept it, because they have created a condition, okay, I will accept under these conditions. So even if you have some conditions, they must be brought on record. After that, then that is the final version, and after that you have to accept that. And once you have accepted the final draft as it is, and then this means that it is unconditional acceptance. So you should understand it this way. Acceptance must be absolute, and it has to be absolute. If like let's take an illustration, like A offers to sell his laptop to B for rupees 20,000. B replies that he will buy only for 15,000. This is not a valid acceptance, because the offer was made for 20,000 and you say that you will buy for 15,000. This means that both parties have not agreed. If you create a consensus beforehand, okay, like both agree on like 17,000, and they bring it on paper, on record, or verbally also, okay, now I accept your counter offer for 17,000, and the other party also agrees. Here, when A and B both agree, then it becomes, of course, a valid offer and valid acceptance, because both have agreed at the final point. So here we are talking about the final point. At the final point, whatever is offered must be agreed, like both the parties should be on the same page. They should agree to whatever offered and whatever accepted. So we should take it in the sense at the final stage, once we have reached the final stage. If we enter into negotiations, that have to be done already. So once we are coming to the final version of the draft or final communication, there must be like unanimity, both are saying the same thing, 17,000 he wants to sell his laptop for, the other person wants to buy it for 17,000 only. So now both agree. So now the acceptance is absolute and there is no conditions. Otherwise we will deem it as negotiations going on, still going on. There is no acceptance. But once there is a final version, then this means there is acceptance. Now expression. The acceptance should be made in a clearly understandable way so that the offerer can understand that it, and you can and the offeree can claim it in the court of law. Acceptance must be communicated. Expressions must be first made and it has to be very clear, and then acceptance must be communicated as well. A person or the party who has accepted the offer must communicate it to the offerer or the person who is making the offer. Acceptance must be communicated by the offeree to the offerer in the manner prescribed. If the offerer wants the communication in a particular way, or if they say that, okay, you need to sign such documents, I am sending you a draft and you need to sign them. So it has to be in the same way. And in case of verbal contracts, of course, there can be verbal contracts, but the offerer should also intend accepting response to their offer in the same way. Like if there is a negotiation between a taxi driver and a passenger, and they come into final agreement, the taxi driver will take the passenger about 100 kilometers away at a particular point and he will charge, say, 100 rupees. So there is a negotiation and both are negotiating verbally. So after all, both agree for 100 rupees. So that in this case, the acceptance has been made by either the taxi driver is the offerer that I will take you to that place, or the passenger asks the taxi driver. Finally, they reach a particular point and they have communicated to each other. So the acceptance must be communicated to the offerer, and acceptance this means that acceptance must come to the knowledge of the offerer. Offerer must know that his offer or their offer has been accepted. Now let's take an illustration. A tells B to communicate his acceptance to him by communication app message on mobile, but B sends his acceptance by post. This will be an invalid acceptance unless B informs A that acceptance is not in accordance with the prescribed manner. So, in this case, we can take another illustration. There are sometimes notices sent by court, and sometimes police also issues summons. There was a ruling by some constitutional court, police used to send summons to someone, and it said summons and notices through WhatsApp. And there were 2 blue ticks. This means that the notice was sent by police, and the party read that because they got 2 blue ticks, and court accepted it. Because court deemed that that person has seen the notice because there were 2 blue ticks, and the WhatsApp number belonged to that party. So this means that communication has been made to the other party to who it was intended by the police. So in this manner, but that was for notice, because notices can be made in any manner that is acceptable by the courts of law, and courts issue rulings from time to time. So WhatsApp messages started being accepted by the courts since then. So if a new case comes, if you go to the court, you can also say, you can cite the ruling that that court has accepted that the notice was served to the party by police. So I am also serving this notice, and other party has read the notice as I got blue ticks. and you can take a video recording or take a snapshot and show to the court. So it goes this way. And now the use of agency, like offer and acceptance can be made by the use of agency. You can use your agent as well. Like in case of corporations, trust, there is trustee, and for government departments there are secretaries representing their department. There may be directors as well, but mostly secretaries represent their departments. So they are like employees. Still there can be some agencies, clearly defined agents, like there is a very popular case that was pertaining to Dunlop company, and that was before independent India, like before independence of India. And in that case, like Dunlop created an agency or an agent, and that agent created a sub-agent, and there was an agreement between agent and the sub-agent, and Dunlop wanted a decree from the court in its favor because its interests were hurt. But court said because Dunlop was not a party to contract, only the agent and the sub-agent were party to contract, so Dunlop did not get any locus over there. But in modern times, if parties' interests are hurt, they are claiming it, and courts are issuing rulings from time to time, and it is according to the scenario created by the society as well as competence of any lawyer that they are able to present a case in the court and convince the jury to issue rulings in their favor. So rulings can be issued from time to time. Like once you see court held sodomy as illegal, then there was a social change. There was a petition filed before the Supreme Court, and then again it validated it. Not validated the sodomy, but validated the same gender relationships. And there was a question because they have validated same gender relationships, and without sodomy it will not be possible in case of gay men. So that is a question, and of course if they have accepted same gender relationships in case of men as well, so they cannot deny, they cannot treat sodomy as illegal, because if someone presents this matter before the court, then by all means, as a natural law of justice, court will have to accept it unless there is that such act was coercive. So this was it regarding the use of agency. Like someone can create an agent, and in India, like an agent is responsible to perform the duties as laid down by their principal, and the principal is also subject to responsibility for the acts